Hello everyone, welcome to Shorthand Battle. I am Divya and I am going to dictate you a legal passage of 650 words at the speed of 130 words per minute. So get ready for the dictation. 3, 2, 1 and go. Applying the said analogy, the claim of the father of the respondent petitioner had already been forwarded and he was very much alive when the government order dated 13 August 2015 was issued. In such a situation, the state government or its concerned department ought to have considered the claim of the respondent petitioner for regularization and then could have proceeded to determine as to whether the respondent petitioner was entitled to any benefit or not. In our opinion, the fortuitous circumstance of the death of the father of the respondent petitioner does not absolve the state government of its obligation to consider the claim of regularization of the father of the respondent petitioner. There can be a case where the consideration has been made and the regularization accepted, but before the order reaches, a man dies or his death takes place in the near vicinity or simultaneously with regularization. In this situation, the claim of regularization of the deceased employee does not remain an option to be ignored by the state government. The state government or its authorities are under an obligation to consider such a claim and to award any consequential benefits if the process has been set into motion, as has happened in the present case. Once the father of the respondent petitioner is found entitled to be regularized as on the date of the government order dated 13 August 2015, on which date he was admittedly alive, then in that event the claim of the respondent petitioner can also be considered. The consideration of the right of being regularized by operation of law while in force had already accrued in favor of the father of the respondent petitioner, and his death in between further gave rise to the expected consequential claim of compassionate appointment of the petitioner provided his father's services were declared regular. The consideration of such right, whether had accrued, does not get eclipsed nor could it be abandoned. If the consideration results in the services of the petitioner's father becoming regular, then the full bench judgment in the case of Pawan Kumar Yadav Supra would not be an impediment for the respondent petitioner to be considered for compassionate appointment. The appellant state and its authorities therefore cannot escape this exercise and defeat the right of consideration by their inaction or the absence of timely and prompt action. Such exercise of consideration will not evaporate because of untimely death, which is a fortuitous circumstance so as to result in any advantage to the state. Apart from this, in the present case, those who were at par with the father of the respondents had been extended the benefit of regularization. This distinguishing feature, therefore, is in addition to the issues involved in the case of Pawan Kumar Yadav Supra, and consequently the claim of the respondent petitioner was at least entitled for consideration by the state government in the light of the observations made herein above. Learned counsel for the appellant state submits that the services of the father of the respondent petitioner could not be straightaway treated to have been regularized, and the learned single judge erred in issuing directions for consideration of appointment on compassionate basis of the petitioner. We agree with the submissions of the learned standing counsel for the appellant, and to that extent the judgment cannot be sustained. Learned single judge also does not appear to have noted the judgment of Pawan Kumar Supra. Consequently, we modify the judgment dated 22 November 2016 to the extent that it shall be open to the appellant state to consider the status of regularization of the father of the respondent and then proceed to take an appropriate decision with regard to the claim of the respondent petitioner for compassionate appointment in the light of the observations made herein above. We may, however, clarify that the ratio of this judgment would be available only prospectively and should not be construed to reopen any decided matter or to initiate a stale claim. Stop.